and welcome again to the series of Tony Talks, again where we talk about bringing properties into ADA compliance and California accessibility. And today again, we're lucky enough to have Laura Utterback from Newmeyer and Dillian in Newport Beach. And Laura is a senior partner there, and she specializes in construction and represents some of the largest contractors here in California. So it's always a treat to have her when we can get her away from her busy schedule to come down and chat with us for a bit. So what are you thinking? What's the newest thing that you've been running across?
Well, I guess what's so challenging, Tony, is we know that there's this barrage of litigation that's out there, frivolous or otherwise. There are issues where a certain, let's say, commercial property strip mall is not perfectly in compliance, right? And what happens is I find that people get this problem fixed, but there's 18 other issues that a certified CASP inspector would be able to find. So how do you best counsel a property owner to address, I'm going to say, the potential for these kind of ADA lawsuits?
That is a great question and a very valuable question. Where property owners fail oftentimes is they're obtaining incorrect advice. And there are typically 4 professional or principles you need to navigate compliance or to navigate out of a lawsuit. And they consist of ADA counsel, ADA design professional, CASP inspector, and an ADA contractor. That's here at ACR what we call our 4-step approach. If you miss any of those tasks, you will most likely be left vulnerable. So the first thing is the CASP inspection to identify all of the corrections that need to be found. Sometimes an ADA attorney, in my opinion, will give the wrong advice and tell their client to only pay attention to the allegations within the lawsuit, which is a bad idea because that law firm is only naming 2 or 3 allegations, hoping you will only correct 3 or 4 allegations when the CASP report tells you there's 15. So
it sounds like with that sort of advice, the lawyer, like, and let's say you're not even in litigation, but you're ultimately setting that property owner up for failure.
You absolutely are. And what happens is if you are caught up in a lawsuit, you're going to be flooded with letters from these attorneys that say they will settle your case for $500 or $1,000 lump sum. Well, think about it. It goes to the old saying, you get what you pay for.
Right.
So if you've got an attorney that is willing to spend just 2 or 3 hours on your case, that's exactly the path he's going to take you down. And you're absolutely right. He's only focusing on this particular complaint and getting it off his desk, not really caring if you get caught up in a second or a third. He may settle it and dismiss it with prejudice with a particular law firm. However, that law firm may have a different plaintiff. There may be multiple plaintiffs that are disabled.
So not only could there be multiple, let's say, violations, but there could be for one single violation, like some violation for the parking, there could be multiple plaintiffs that were allegedly impacted by that same violation. Is that correct?
There could be, yes, absolutely. And that's part of, once these things are filed and they're public record, these law firms and these plaintiffs are looking at the information on how they're settled, what the allegations are. Some of them may file electronically a lawsuit piggybacking on another and never even been to the property. So it's important how to navigate through protecting the property. And when we act as a design professional, my intent is to obtain a permit on the property. And the reason I want a permit on the property is to protect the property owner. You now have a date and a threshold on when the property was brought into compliance. And it's recorded with the local authority or local jurisdiction. And from that particular point, you don't have to modify to the newest upgrades unless you've made a major renovation.
Okay, that's good to know.
That's in California. However, you have the ADA side that comes in and says that you need to remove the barriers. So you got to be careful with the advice that you're getting. Some of the attorneys are only paying attention to the allegations and the lawsuit in front of them. We look at the overall picture, and we insist on documentation, 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 and that's how we protect our clients.
And as we wrap up this Tony talk, if we go around full circle, currently the best advice I can give current clients, no lawsuit has happened yet, but I introduce them to you as the CASP inspector, the ADA design specialist, as well as an ADA contractor, and let's be proactive. Let's bring the property up to compliance and make ourselves, as we previously have said, as bulletproof as possible, correct?
Absolutely, and that is the best way to bring the property and the owners into the best protection out there.
Yes, and not ever needing to have a lawyer in that regard.
Well, thank you for joining us again today. It's always a pleasure.
Of course.